Hello, hello, hello. Good afternoon, good evening, good morning, wherever on the in the world. This is Mohammed Shilon coming to you from the United States. I'm on today with my co-host, Mr. Victor Mengot from Surrey, England. And so welcome on back, the listeners, hoping that, as usual, we'll go engage each other within the constructive framework that we always try to promote, and that we go do justice to ourselves and to the people them and try to cover some of the subjects and matter the whole one for discuss. So of course this is not VOS television. And say today September 28th, Sunday, September 28th, 2025. So as usual again, we always try to make one see what would how for reach we, how for interact with we, and when we can listen to we from time to time. When I know say this na interactive show is live, it's not pre-recorded. Therefore, you can call anytime if you're listening. If you happen for catch we, you can record anytime. And we standard time now 4 hours difference with here in Salon. And that would go by. So Sierra Leone by now, it will be shortly after 8 o'clock. And of course, Britain then plays them there about 5 hours ahead. So then they are ahead of we. So it's Mekos, they operate a little bit later than Salon time. So with all of that, I just want to give you some of the places them, or when I can able reach we, the platforms them. So, say you can go on YouTube if you dial VOS Television, or Facebook, VOS Television, or X, where it formerly used to be Twitter, VOS Television. You will be able for reach we, and also you get VOS Television websites in conjunction with the VOS Television I just mentioned to now. We're at www.vostelevision.com. If you go on www.vostelevision.com, you will be able for catch we also. Of course, if you go on YouTube, you go run into we too, as far as if not live immediately after the broadcasting, you will be able to see this program. Immediately after. Then we get what you call VOS radio television. VOS radio website, not television. We're at www.vosradio.com. The vosradio.com, on a 91.9 FM. In addition, if you want to get out of the .com part and you want to listen to her on the radio, then you get for going at the VOS, at the Google Play Store or the Apple App Store and download the VOS app. The VOS app. A VOS app go make you, the mobile app, it go enable you for your railway on 91.9 FM. And as I usually can tell people, if you just go on 91.9 FM, if you're in North America, Canada, Mexico, United States, there's a high likelihood that there is an existing 91.9 FM station, or not a VOS station. That make you need to get the app. So you're not going to be able to catch you, but once you get the app, you will hear and clearly, no matter what part of the world you're there. Also, then, of course, if you go on Google, you will able to get free. If you go on Twitch TV, you will able to get free on VOS television. In addition to that, there's another thing we can always direct people attention to. Now we're www.VOS Diaspora organization. That's another VOS www.vosdiaspora.org. If you go and the website, and you dial that, vosdiaspora.org, you will see this we helping hand a non-profit organization where we will promote now for help young, aspiring, or hardworking Sierra Leoneans. Then we want to go to school, but money no day, or they not get the money for put them in school, or for the one that with school, not for drop out of school. So we always ask, say, now it's a non-profit organization, so it should be an open case. So if you send money and you want to know how things are being operated, you should feel free for call the VOS non-profit organization for tell you which in the go on. And then, of course, no amount is too much, no amount is too small. Send anything you can. And from time to time, the organization will give you an update on how things are going, who that have been helped, and whose part of the country. Some of our schools, they pick in, they will get the benefit of what the assistance will promote. So with that said, as I said earlier, I was my co-host, Mr. Victor Mengot, who needs no introduction. But I will pass it over to him. And I will ask Mr. Mengot introduce the topic. I go introduce the headline, I'm going to introduce the topics, and then we'll go from there. We main headline today, or topic today, will be Judiciary Under Scrutiny and Data Protection Bill when they try for, I will introduce when they try for personal parliament. So, can Sierra Leone deliver justice and digital trust? That's the topic. Judiciary Under Scrutiny and Data Protection Bill. There are ancillary issues concerning this headline in terms of judiciary we're going for touch on. Two of which are an ongoing saga between a sitting judge and a young girlfriend, and then the other one are the Chief Justice with a sitting judge also, another saga between them. And we'll go raise some issues as to the process, the fairness of the process, and whether the process needs some revamping, and so on and so forth. So with that said, let me turn it over to me co-host, Mr. Victor Mengot. Over to you, Mr. Mengot.
Thank you very much. Fambule and Akushe, we don't come back, and we can look at two issues today. We mean Victor Mengot, I recall from Surrey, at the joining now, and we come, the two issues, I know say, they get a lot of legal implications. And if you look at we headline, Judiciary Under Scrutiny. Why? Because we don't see, say, boku people don't complain about how we judges then they behave, how the courts then they behave, the processes where then they go through for get justice. And there's a lot of concern. But now we get a situation where even the one the way they within the place, we don't see them safe. They don't get in the way they affect them. About the law of the land. The law of the land, well, but the main law, now the Constitution. And then other laws they will get laws them will deal with bylaws, when a local government laws them. But if we not get the law right, and people are not satisfied with the law, we need to review them. And the people that we actually give that power there for administer the law, we get for trust them. But if they safe, they get small robots, who then are we? We they see accusations and counter accusations. a Supreme Court judge, the accused behave to in terms of the entitlement and not get freedom for work. So now then thing they can look at. Then you get the issue again where me and my colleague can talk about the equal. We realize that the president get enormous power. And when complaint comes that the president and get for go to, and the president don't follow the law. But now this same too for the girl the time thing we very important to want to talk about. Now this new bill where they go through parliament, where they call the Sierra Leone Data Protection and Regulation Commission Bill. One thing I can say, we see say the government don't they go around for say they do consultation. And my colleague now, he get in view about this consultation, waiting a consultation. When one thing we get for make sure say we make government know and the people the way they, we get parliament. Parliament get websites. If you go to the parliament, you look at how parliament operates, then get section where get bills and motions and everything. But how come we they discuss a bill where even the very parliament where now they discuss this bill, and this bill is championed by the Ministry of Information and Civic Education, we don't see the bill. It's not in the parliamentary website. And by law, this bill also should be gazetted them the chance for law look am, and some of we where they serving selflessly, because data protection are very important thing. Would I hear anything about the national identification number? And the idea say you get for get them, you get for link to your telephone number, and other people and they where they get access to that data there. We get data where it relates to you motorcar. If you go for roadworthiness test, what I mean by roadworthiness test, that test where they go make sure say you motorcar fit for going on the road. That data there also other people and they go get access. Recently we hear it don't scarce. Although now Sierra Leone Road Safety Authority they issue license, but we rely on other people for so and then data and then a very important thing them where people like use them and misuse them and abuse them. So how sure are we that they don't use them for other things? And then they talk about a regulatory body. What they set up the regulatory body here is good for setup, but do they have the right personnel? Do they have the technical competence? Do they have the funding? So now all that we get for begin examining, because recently they say as from the 1st of September, then they begin check people the way they deal with that at the National Civic Regulation Authority, NACRA. We also get agency where they deal with right to access information, where every citizen get right to get information about the government. To what extent citizens then get access there for check about whether they use or misuse the data. So these are all the things that we get today. We'll all start with the judiciary under scrutiny. So over to you, sir.
All right. Now we get two trending matters of late. Well, actually trending means of late. We involve the judiciary or the legal system. We, again, sometimes we want to let people understand we are strongly encouraging we officials them, or we authorities them, where they want for try for implement certain things. Again, let me say this. With legal profession in Sierra Leone, the pedigree of that profession there in Sierra Leone is from a very distinguished legal ancestry, and it's a system that has been very well tried, and we've really tried to live up to the good image of the profession itself. I always try to tell people and say, I'm not so sure, because in America, I wouldn't refer to it as the noble profession as is commonly used, maybe in England and in Sierra Leone. We don't use phrases like learned counsel, my learned brother, and this kind of thing, because we just assume, say, not to lawyers, not the only learned people, them, so we'll not get a monopoly of to that phrase there. Engineers are learned people, doctors are learned, professors are learned, and so are so many other occupations and professions. So we just kind of hijack that thing there. They use that as if it's a phrase that can be only used to lawyers. But since we go by that, well, we'll not just take that title there or that phrase, they attach them as an accolade, as a title, and then we behave like we are not learned. We will live up to the true spirit of the phrase, learned. So, when we try for talk about passing laws, we try for implement certain things, we just not for the go copy things them back home from other countries or read them over the internet. And then begin to say, oh, okay, let me introduce this without having people that will get a real practical knowledge of some of them phrases here. Because, for example, recently I see when they talk, say that they can propose some changes again, as if it wasn't bad enough when they do this substantive change of the system by getting rid of the jury system, which I think is a colossal mistake, and I think it's such a mistake to just abolish something where they're in existence for over a century in our country without having tested an alternative system to it to see how successful the other system did. We just decide, say, we'll get rid of that system without even giving the country a reason why the jury system is being gotten rid of, and we try for invite people, the list or the most we had mentioned it on this show before with somebody from the profession was once upon a time when we get lawyer Magai, Charles Magai, when in Justice we mentioned that in passing that there was talk or consideration about getting rid of the jury system. When I immediately said to her, I don't think that's a wise idea, but it's debatable. There may be a stronger case to be made in support of getting rid of it, which I'm sure has never been made to the contrary for tell you why such is a significant change for something will so impact the rights, privileges, protection of citizens. We just get a handful of people who made this decision without really even trying to, because I've always raised the issue about pilot program. Pilot program is when we think of an idea, you can test it in some part of the country, put them as a testing thing. You can pick a district, or you can pick a judicial district within a administrative district. What do I mean by that? Let's say you can say Kenema district. Okay, we go try for when a administrative district, you can come up say, all right, we want to test this system. So what you will do every time we hold courts in a Panguma or in a Tongofield, on a hanger, on a blammer, any jurisdiction or that, well, this is the system, we're going to try that and see how workable that system there is. We don't tend to do that. What we tend to do is to try to just introduce something because we read them, and the people who are making these changes don't have any practical idea, not even a thorough understanding of what they're trying to replace and implement. This is what, so if we notice, we tend not to go forward because we make change for change's sake. So now we're back to this thing about this judicial scandal. There's a big thing going on with the Chief Justice and one of the sitting judges, Justice Halloway. Justice Halloway has all kinds of accusations against the sitting Chief Justice. And I would have thought, and I know there is such a thing, about a process whereby a judge can lodge in dissatisfaction or complaint about a fellow judge, a colleague of his, or the Chief Justice, or the registrar of the court, and so on. Okay? There is a system laid out by the white people or the colonial masters. There was such a system after independence, before independence and after independence. So you just wonder, how did we get to that administrative system that was in place to take care of grievances by judges and the necessary steps? Because every time there is a basic method of trying to get a hearing, there always have to be what you would call appellate or process, a process by which if the person is not satisfied with the outcome of that hearing, they for appeal. So I mean, right now we get a situation where Justice Halloway had gotten into this issue with the Chief Justice with respect to gross unfair interference with the daily operation of the judge's work performance. That they say the Chief Justice interfere. That the Chief Justice, they interfere with cases then we pending in courtroom. That the Chief Justice, they try to penalize them and they obstruct them in so many ways, because in a lot of ways, when the judges begin to say that, you can say the Chief Justice is engaged in obstruction of justice. You know, these are very serious accusations. So what are the methods, mechanism by which such a thing is taken care of? And in this day and age, when we get social media, if you're not in the regulations, if you're not in the rules, it's time for them to begin to take that into account. How do you incorporate into the existing system with respect to the regulation of the utterances of judges without infringing on the right to free speech? And how do we incorporate this electronic involvement in the entire in the overall operation of the administration of judges? To what extent can a judge go on? Because a judge, also the fact that he's a judge doesn't mean he loses his constitutional rights. So a judge has a right to free speech, but a judge is also governed by ethical considerations. So how does that judge work the fine line between ethical guidelines and the exercise of free speech? And any regulation would then pass will interfere with that. How do you test the overreach of such a regulation which will prevent a judge from speaking as a citizen vis-a-vis him being in violation of some administrative regulation? So it's a complex thing. So what we have here now, we have this Judge Halloway, or Justice Halloway, and the Chief Justice at each other's throat. But now what is so interesting, I can even say amazing, you get what you call the Judicial Service Commission. So now it appears as if the Chief Justice seems to be the man in charge. Now the Chief Justice, I understand this thing is going before this dispute between the judge and the Chief Justice has now gone before the Judicial Service Commission. But the Chief Justice against whom Justice Halloway is complaining seems to be part of that body who will decide the judge in your fate, which to me doesn't make any sense. Because if in fact, the order for the Chief Justice, for the judge to appear and to, in fact, then I understand the judge has been suspended. These are all things of which the Chief Justice has a say-so. So it's just unbelievable that the Chief Justice, who is the subject of the complaint, also they play a role, and because he's the accused, and then he's playing the role of being part of the decision maker. So I find that to be so basic, and I know the caliber of judges them back home. They seem to be very well read, so they should know better. They should know better in the sense that the Chief Justice should not have any part of this process what they do with Justice Halloway at all. The only time the Chief Justice for even being involved now as a witness, if you want to testify before the commission, if there are facts that he disagrees and he gets certainty, and then when he do so, then you get for implement due process, whereby the other side forget the right to respond, the other side forget adequate notice. Other than that, I just don't see any role with the Chief Justice for playing where the complaint is, or the issue is about him and the judge. But there I find the Chief Justice under this Justice Halloway issue, he is playing a major role. So I'm not convinced that the Chief Justice doesn't know any better, or does he know that he should recuse himself? I know he knows that. I know if he doesn't do that, Justice Halloway, he young lawyer. This is another thing I don't understand. So far, by what I've read, Justice Halloway seemed to be, I don't see any instance whereby he's being represented by counsel. I would think in a situation like that, Justice Halloway will be better served by having counsel, since this is a different forum that they are appearing. So I don't see how Justice Halloway wants to handle himself, not because he doesn't have what it takes, but it just looks more balanced, more respectful, for treat the system with the respect the system deserves. You know, go there and make your appearance, be humble, and make an effective presentation. And you don't have to have an attorney, but in this country, in the United States, no judge will have such an issue before a regulatory commission or authority. He is not represented by an attorney. I cannot even imagine that. But that's what seems to be the case right now in Sierra Leone, whereby Justice Halloway. And then the other twist to that situation there, you get the president's office playing a major role here. And I mean, again, I've always said, I don't know why so much authority is given to the executive branch. The Chief Justice, the President get hands in appointing judges. The President get hands in firing judges. The President get hands in appointing clerk to Parliament. The President get hands in punishing clerk and certain things. And so I have the opinion that we still don't have the basic understanding, this basic understanding of the three co-equal branches of government. They don't say three branches, so they should be co-equal, equally for maintain the balance of making the system run efficiently. They should be equal, which means Parliament, as as the most persuasive or powerful of the three, it seems like. Then for the head of Parliament and the Speaker of the House, and the President should have nothing to do by way of appointment of anyone in Parliament for any position. But here in Sierra Leone, we see where they say, I think the Constitution say the President is a member of Parliament, which I find to be ridiculous. Okay, the President should not be at all. So the bookman will put that phrase together. I mean, it behooves me to ask what were they thinking of. It not sound like these are people who take basic, the first semester of constitutional law whatsoever. Because the President should not be a member of Parliament. Because if he is a member of Parliament, then it is a true electoral capacity. As a member of Parliament, then as President. So it just makes the whole thing ridiculous. So what that tells me, the people the way they copy them phrase here, they put in a constitution, this and that, they don't understand which is the meaning of the and they just put on there. But then the President now, as head of the executive that is supposed to be independent of the judiciary, he has the responsibility and the power to appoint the clerk, the chief administrator of Parliament. So how are they separate or co-equal? The President now is President, is a member of Parliament, is President of the country, and then the other branch within the judiciary, where once a Chief Justice is appointed, he is the man in charge. That President, that Chief Justice is subject to the whim of the President. This is how the laws are written. Then we ask for justice. When we don't give power to one man, now one office, say it can meddle with the activities of the other two branches, the legislature and the judiciary. So when you see them, you begin to wonder, say, well, you can for question the knowledge of the people and we'll put them rules there together. As much as you may not want to, and as much as we want for bring them, I will show them for say, please explain it to us. And there may be some sound, philosophical, well thought out idea will make them write the Constitution in such a way for say the President is a member of Parliament. I mean, monopoly, nobody has a domination on it. The frustrating part about we on show is that we try to get some of the officials here for come for explain. For say, please come on board. We get questions along with the public. Come aboard and allow we ask you questions then. Why are things the way they are? Don't you think that's why sometimes when I try to implement things, when I can implement them, but when we're not able to enforce them because you're not workable, but we don't get these people. They are always busy. Then the posture, then will tell you, say, I get conference for going to New York. I get United Nations this. I get African Union that. I get ECOWAS this and that. Some of which I call grandstanding. Because if you are not grandstanding, you go give alternative dates and say, well, I'll be going to New York at the UN for such and such, but I'll be available from this period to this period. That indicates an intent to want for respond to an issue that we're concerned about. So, but the judiciary now, where you have judges fighting judges, and they don't seem to be able to get a structured system which once existed, which I know on the books still exists as a process for handling dispute in there. But we have gone into this thing of undermining existing procedures and processes. And by so doing, would make nothing workable and just create more and more problem. There is another issue I could touch on, but let me stop right here and just get my co-host. Let me just touch that because then we also see this ongoing thing, saga, with the trend of Justice Stevens. I think his name is Momoja Stevens, and some young lady who says she's 21 years old. She has a video, so we'll ask the control room for show the video before I comment on that. Then I go ask my co-host if they get anything for say on that. So let the control room show with this video.
Good afternoon, everyone. My name is Edwina Awajamiru. I'm Justice Momoja Stevens' baby mama. Justice Momoja Stevens has been doing a lot of bad things to me in this country. Got me pregnant, gave birth to the baby, raped me, took my belongings, and I reported the matter to the police, but they are taking it light with him because he's a judge. He abuses his powers as a judge. Him raping me, beating me up, doing all those things to me, offended me a lot. And I reported the matter to the police, and they didn't do anything because he's a judge. But the fact that he is stopping me from going to the court at Shakastini Street, I try to go there, he orders the security not to allow me in, as if his father or himself is the owner of that court. That's one thing I'm against. Justice Momoja Stevens should not stop me from going to the court. The court is not his personal property. He's even stopping me from going to Frobe College, which is very, very wrong. Frobe College is not his personal institution. His father didn't build that university for him at all. So he has no rights to stop me from going anywhere in Sierra Leone. Another thing that angers me the most about this judge is the fact that he acts like a poor man when he has money. He's being a stingy judge. Instead of him spending money on his child, which I've given birth to for him, he's being stingy. He does not want to give the money that I want him to give for his daughter every month. He's acting very stingy, and that's one thing that I hate about that judge. My people, those that know Justice Momoja Stevens, if you know him very well, tell him that if he doesn't stop this act of being stingy towards my child, towards my daughter, this fight between me and him is going to continue, because he's meant to be spending money on his daughter. Nobody helped him when he was having sex with going to help him to take care of his child. All the financial bills and responsibility is going to be on his head single-handedly. He should spend his money. That money, my child is meant to chop his money. He's meant to eat his money. And if he dares try to be stingy towards me and my child, I'm going to be very, very mad with him. So I want him to spend money on my daughter. He's refusing to spend money on my child, does not want to take up his responsibility, does not want to finance the child. Even the money that he's giving for the child's upkeep is as tiny as what I can comprehend. A man that is so wealthy, he does not want to spend his money. He must spend his money. And that money for my child's upkeep, I must receive it. My child must benefit from the resources of Justice Momoja Stevens. That is the reason why he impregnated me. If he didn't want all of this, he should not have had sex with me and impregnated me. He's an evil judge. A judge that takes advantage of women and girls, impregnates women and girls, and wants to run away from his responsibility, or wants to treat me like an ordinary woman, or like one random lady. I'm not a random lady. I'm a lady that is knowledgeable and knows what she wants in life. And what I want is for Justice Momoja Stevens to spend money on my daughter, to spend his money on my daughter. My daughter must eat part of his wealth that he makes. This is what I want, and I really want him to do it. He should not be stingy towards spending the money that is meant to be spending on my daughter. If he thinks being stingy is the only thing that he's gonna do, I'm gonna make sure that this fight between me and him never ends until he gives me the money that I want him to be giving me every month for my daughter's support. Thank you so much for listening to me. And that judge is an evil judge. The fact that he's stopping me from going to that court is something that I'm against. Nobody should stop me from going anywhere that I want to go. I'm free in Sierra Leone, and if I want to go anywhere, I'm free to go anywhere. and he must perform his responsibility to his child. He must spend the money. My daughter must chop the money of Justice Momoja Stevens big time. If he didn't want to spend his money, he should not have impregnated me by having sex with me and I've given birth to his daughter. And now that I have his daughter, he should spend money on my daughter. And if he doesn't want to spend money on my daughter, that fight is not going to stop until he does what he's supposed to do. This is what I want. And until I get it, I will not keep my mouth shut. I will not be silent, because such a man is evil. Wanting to have sex with a woman like my type, wanting to have sex with girls and women and then abandon them. I'm not one such lady. He got sex with me, have a baby with him now, and he must take care of his baby. He must spend his money on my child. That money must be given for my baby's upkeep.
All right, all right. Let me see if my co-host has any comments. I know I do, but I've already spoken quite a bit, so I don't want to preempt Mr. Mengot. I see if I'm the only one here. So, Mr. Mengot, what say you, sir? Back to you.
Okay. I will go back to looking at, because you've spoken a lot about the conduct of judges, the system we have. We institutions, we lost them, and some of the lapses and ethics. You mentioned about the Judicial and Legal Service Commission, right? Let me talk about that and what's in the law say. Now, the Judicial and Legal Service Commission, now a commission which is mandated by the Constitution. Of the Constitution, now that they tell we waiting at the Judicial and Legal Service Commission, the role. They set this commission so that this commission now is responsible for advise the Chief Justice. And it's interesting that if that the commission responsible for advise the Chief Justice, and the Chief Justice is now the chairman of the commission, that is where the law is faltered. Because it would have been good that the Chief Justice can be part of the commission, because I am responsible for the conduct of judges them and other staff in the judiciary. But in the case of natural justice and impartiality, I think that section of the Constitution needs amended, whereby the chairman of the commission should be independent, a retired judge. Now, just like England, when they get issue with those things, from what you understand, who are they can get a commissioner. And then commissioner where they can get for looking to issues. Now retired judge, then the independent person. Because in law, you're not a lawyer. You know, there's a Latin phrase, but in law it says, a man cannot be a judge in a case where he gets a cause in. In this case, Justice Halloway, he accused the Chief Justice of things then. But now look at both ways. Even with Justice Halloway, now the approach, because in any organization, you must get complaints procedure. You must get redress mechanism. The drafters of the Constitution, they are not stupid. When you look at who are the people in the Justice and Legal Services Commission, you get the Solicitor General. Who is the Solicitor General? He's one of the legal advisors to the government. You get somebody from the Public Service Commission. You get somebody from the Bar Association. You also get people then when are independent people then two when are the president they appoint they win to legal person. Let's put it this way. Judges are also public servants. And if you look at the Constitution, it says under Section 142 of the Constitution, it talks about the appointment of officers and servants of the court. But in subsection 2 says the Judicial and Legal Service Commission may, acting in consultation with the Public Service Commission and with the prior approval of the President, make regulations by statutory instrument prescribing the terms and conditions and service of officers and other employees of the court and of the judicial and legal services established by the law. Why? What you know they quote this year, right? There must be a form, a statutory instrument, when I define the roles, responsibility of the judges. And with responsibility comes rights and procedures. So there should be a complaint mechanism when nobody not explain to we waiting at this complaint mechanism. That is where I see there's a flaw in the whole system. Because what it says here, the procedure is the commission met. And when the commission meets, Uda Dede, the Chief Justice, Naina, the chairman of the commission, he now recommended to the president, as per law, that this man be investigated. And the law also say, if the judge is going to be under investigation, the president get right for suspend him and form a tribunal. Now the president, they set up that tribunal day. And in setting up that tribunal, he will seek the advice. And who he will seek the advice of? Now the Attorney General and Minister of Justice. That is where we have another conflict, as you say. Because they don't talk, say, we for look at that issue. Because the Attorney General and Minister of Justice occupy two positions. On the one hand, he is part of the judiciary. Because they are the government legal advisor. On the other hand, he is a Minister of Justice, which is part of the executive. So the man get two hats. So now he get for tell the president and advise him who then three people here we get for being at the tribunal. We go be superior judges. A Supreme Court judge. Now so the law say. Then people and they go look into the conduct of Justice Halloway. We're waiting in the charge for now misconduct because the law say you can hold an investigation into a judge if in case of affirmity or a misconduct, then the tribunal go meet. When the tribunal meet, the tribunal now go get a report where they will give president. President go consider the report. It's only the president will get right for say, okay, I don't agree with the recommendation or agree. But if the president agree with the recommendation, now it now goes to parliament. When it goes to parliament, now the parliamentarians now get for look at the recommendation and then vote for uphold them. And when they say for uphold them, they say for sack the judge, it means parliament get for get a 2/3 majority for say yes, the tribunal. Then they go with the tribunal. Where I find the flaw in that, I will consider. They're not going to look at the man we complain again. Oh. You don't done. The man we complain, he only gets time for face the tribunal. And when he face the tribunal, you remember say a similar thing be happened to the Auditor General, where the question will go about rules of procedures. You are a legal man, you go tell me that rules of procedures is what they go accept, what they not go accept, and how they will conduct the tribunal. So that is one issue. Namio comment down. So the law and the institutional setup needs review. Because yes, I agree, say the Chief Justice now in charge of administration, but we have to look at say whether, in this case, even if not the chair, I think it be for reclusing himself from the case. Get another judge, because you get a Supreme Court judge, you get an appeal court judge. We go chair him, and he go actually say, well, there's a vested interest. He not go take part in the decision making, because that would be unfair, not the right of natural justice, before they make the recommendation. Then also, Justice Halloway self, we don't know when he writes complaining about the judge, he therefore writes complaining about and quote in terms of office, in conditions of service under a statutory instrument, whether he followed the right procedure in making in complaint. That we don't know. A parallel to this, now this other case we mentioned with Justice Momoja Stevens. From where to the area, he gets in touch with this lady, young lady, because now a student at Fobe College. And if you're a student, first the college therefore take issue on that. Because I know say, if you are a lecturer, you get involvement with the student. In most universities, in the university like where we attend then country here, that straight away means say ethics demand that you cannot be trusted, because there is no way a lecturer forgets business with his student to the extent that the student get pregnant and born for him. But me not a judge him, but then the one thing that then, given by watching this lady don't go out, means put it into disrepute. In my own view, that is also tantamount to misconduct. How come this case not go before the Judicial and Legal Services Commission? Maybe we'll go there. I don't know. So now my own view Andy, about the institutional lapses, natural justice, and fairness. Over to you, sir.
Thank you very much, Mr. Mengot. Well, like you say, I couldn't state it any better, because sometimes I always question the relevance of the overlapping responsibilities of some of them government offices there. Because you get a Judicial Service Commission, then in claims say you get it when they want to take such an administrative action involving judges, you get for consult the Public Service Commission. I would just like to know the rationale of the Public Service Commission being involved in grievances of a judge or grievances of judicial matter, why Public Service Commission will gain enhanced day. Then they say you forget the approval of the I think the approval of the president or the Public Service Commission itself. And what would they do with the Judicial Service Commission? I just wonder why all the overlapping responsibility here, Mr. Mengot. Am I stating it clearly, or am I missing something about the commission, the Public Service Commission, the responsibility when at the initial body to which a complaint is brought, either by a judge or by someone from outside against a judge? So then there is some indication that the Public Service Commission is brought into it. Then the president is brought into it. Can you just explain to me again how that is done, or what do they do, or how it's not overlapping? Why does it that doesn't create a monotony
Okay.
Go one.
Number one, the Judicial and Legal Service Commission is responsible for the administration and everything to do with judges and other people the way they work in the judiciary, than at the Judicial and Legal Service Commission.
Mhm.
And within that commission, the Chief Justice is the chairman of the commission. But where the controversy lies, the law say the commission, now they advise the Chief Justice. That is the point I'm making. So if in a chairman of that commission, and our same commission, they advise him in performing an administrative duty, then there's some kind of thing we'll get for look, say, well, it's like a case of physician heal thyself. That is one point. But the Public Service Commission is represented in the Judicial and Legal Service Commission. So when it comes to outside the Public Service Commission come inside, I go refer to the law. Now, when it comes to the terms and conditions of service of them, the judges them. And then they under section 142, subparagraph 2 of the Constitution. And law broken down. It said the Judicial and Legal Service Commission may, acting in consultation with the Public Service Commission and with prior approval of the President. So even if they want to do, they get forget approval of the President, now then they make regulations by statutory instrument. When they make regulation by statutory instrument, it means that you get to present that statutory instrument in a parliament when they prescribe the terms and conditions of service of courts and of the Judicial and Legal Service Commission. So you see, that is where the thing comes. First of all, the Public Service Commission get prior approval from the parliament, from the president. Once you don't get that prior approval, next, now you get for set the terms and conditions of service. And when they set terms and conditions of service, as you know, even when you're an employer, we don't give you letter of employment, we don't give you terms of conditions of service. Within that terms and conditions of service, they must get redress mechanism and grievance procedure. Right? But when they do them, for let it be legal, it get to go through parliament through a statutory instrument. What's in a statutory instrument? A statutory instrument is a secondary legislation. And me and you don't talk now, but could tell about how they pass statutory instrument. Where if you go to parliament for oppose them or challenge them, there has to be a 2/3 majority. If not, after 21 days, it becomes law. So you see the process. The Public Service Commission, working with the JLSC, first of all, get for seek approval from President for set terms and conditions for judges and all other people them. And then that terms and conditions should be presented in a statutory instrument which should be approved by Parliament. So there's a lot of conundrum maze. So I think that's the best way that I can explain it.
Okay, thank you very much. Well, one of the basic things then we didn't teach you in a law school, in fact, another teach you how to become a draftsman, then they teach you how to write in plain, simple way for people to understand, and for make sure say what you write is not subject to multiple understanding or interpretation. That's why sometimes they can talk about the intent of the law as opposed to whether the law itself, as it is drafted, clearly expresses the intent. Because that's where draftsmanship comes into being. But when we talk about draftsmanship, sometimes we can tend for things say, and a special skill. Well, it's a skill, but it's not special. It's just a matter of writing so people can understand and not to misinterpret what they read. If I say on September 30th at 2:30 p.m., I'll be going to visit Mr. Victor Mengot at his residence, and I'll be going by taxi. That's explained. Nobody not forget difficulty for understand that. Because it's very simply stated. He expressed me intent. It expressed where I'm going. I did not give a reason why I'm going, so you can't add anything to it, but it's as plain as day what I'm going to do on that day for go see Mr. Mengot. Now, I think where the trouble lies, where we can sometimes one try for overplay with hands, particularly not for Western people then, but for we back home, we learn English as a second language or third language or fourth language. We want to show how much command of the English language we get. We can try for be fancy with the language and sometimes put in words that may imply what you never had in mind. And then we get into all in confusion there. But this is the way our laws are. As you listen to Mr. Mengot, they talk about, I call them overlapping responsibilities or necessary connections of rules and regulations. And in front of trying to streamline the system, we make it so complex and complicated. Because when you begin to get Judicial and Legal Service Commission interacting with Public Service Commission, interacting with the President's office, and so on and so forth, when it could have just been simply a situation where you empower the Judicial Legal Service Commission, you give them the authority to either regulate the conduct of lawyers and judges, or let us say judges in particular, because lawyers are all not part of the Public Service Commission, because judges are civil servants, and the Public Service Commission has a lot to do with the from the employment to the activities of civil servants. But why not be? But if we talk about disciplinary conduct or disciplinary power, why not just entrust them in the hands of the Judicial Legal Service Commission? Why bring in the Public Service Commission? Then you draft it and make it discretionary by saying may. So it's not mandatory. So you give the Public Service Commission this broad latitude of discretionary power, okay, which is subject to one person's interpretation that since it says may, I can say for whatever reason, the Judicial Service or the Public Service Commission ought to get involved. Then you compound it with saying, with the approval of the President. Somebody tell me, how or why is the involvement of the President necessary in this context? If you want for discipline, or if there is a complaint, if there is if there is a complaint on discipline or any reason, why President forget any hands, the office or the President forget any hands in that? But this is how the regulations are written. So when you write the regulations that way, you make it almost impossible. Then, listen to Mr. Mengot. Then, after decisions, after you take the very necessary steps, and now these regulations may have been written before independence. And when we get the common law practices, since we get independence, we'll draw a constitution. Now we get an overriding body of laws called the Constitution. with which all the activities and laws passed by Parliament must conform. They must conform with the Constitution. Okay, so now we get regulations that were once written when there was not the existence of a constitution. So then laws here or then regulations here did not take into account due process, will involve the right of adequate notice, will involve representation by counsel, and these are all things that must be spelled out. Then now we'll get the law go as far as after all this exercise and the commission don't get involved, the commissions don't get involved, then it goes back to Parliament. What kind of process is that? But once Parliament does kick something out or by way of passing a law, they should have nothing else to do with it. The interpretation of it, the execution of it should be under normal process for go to the judicial system. If it can be interpreted in a way that is sensible, when it makes sense out of the law that Parliament passed. You don't call Parliament and tell them to come and explain. The court makes sense out of what it is. If it cannot be clearly defined, the court has options. They can strike that law as being illegal, unconstitutional, and they can strike it as being unconstitutional just out of vagueness, that it is not clearly puts the person, the defendant, the respondent, give adequate notice as to what he or she is being accused of. But the court has the power to strike that law, or the court can send them go back to Congress or Parliament and say, listen, this law, as we see them, it is not as clear, but one given a second chance for write them clearly. But most times the law will just strike it on the basis of, the court will just strike it. So we've skipped all anything in there. We know what you will not do. We don't go back and do the basic work then what we get for do. That's why we get civil service, we get civil servant. So now we get a situation where you get a judge, and I've not seen any accusation against the judge that he has not followed procedure, the existing procedure. So it's hard to say the judge complained about the Chief Justice, they interfere with an everyday operation of his duties, and the judge, they make it impossible and they obstruct him. But I haven't, so whether he went about it the right way, I have not seen any accusation as yet that he did not follow either protocol or process or procedure. So these are the things that, as basic as they look, for move forward, for the try for clarify them here and improve them here. Not if we can begin talk about you want change Freetown to 6 cities, you want to have 10 more districts in the country. These are heavy lifting, which we clearly not get the ability for sustain. We don't. Intellectually, financially, these are great over ambitious endeavors that we cannot successfully pursue. And we know that. So this is an attempt to just destroy an existing system that needs so much restructuring. But let me stop here. Let me just, then I will comment on the Momo Jazz Stevens situation. Let me take a call. Hello, caller. What's your name? Who's to call from?
Good evening again, gentlemen. Let's see if, good evening.
Good evening.
Thank you for the program.
Good evening.
Again. The thing is that I don't know. I'm glad you won't knock out this topic because I've been getting always a question about this statutory law. I don't know if Nasalo no more this law day. Do have someone going to help me? Why on earth, if you go to law na Parliament or you go to any kind of regulation na Parliament, they say if you challenge them now, you need 2/3. Why the possible they count them? Not to even forget the 2/3, but you want to challenge them. We mostly in our opposition, we in governance. It's not part of bad governance. Because Because me, this thing don't dey always baffle me. Where they say the count ya, it will take 21 days na ya. But all the part of the world, the way me they see, the people in county bill, what government county bill, now they forget the majority for defend them, that thing they. But not to say me if I challenge them, I forget a 2/3, not only no just majority, I forget 2/3. Well, it's not possible. This is not therefore do with the fact the constitution what they talk about, it don't they will think say APC go in the power for so long so that they will make it difficult for the one who go dey the other side. Now today don't come hold all man at the truth. Now so me see this here. Because even this one I talk about the law about the DLC for Komoya Goyanda, I don't talk we go get the best of the laws in the world. But if you take that power, you give them to one man, that law will don't make the function. Look what happened in Malawi. The president, because they don't strengthen that the judiciary, the president want to interfere for the count of the votes. The court tell and say, come on, you know, get no business here, will continue for count. But alone, look what happened with this judge when I talk about. They say they don't even get the chance for defending himself. A judge, it's an appeals court or a Supreme Court judge, they don't even get an opportunity for let him defend himself. They make a case against him. They don't ask him to come there in person to come defend. They make a resolution say, "Men and carry on a tribunal." The other judge, which he don't they raise an objection. They say no. They make an objection here. This is not the judge and the treat so. So we all know things say all of these things get for do for the fact say the way they structure this constitution now for make one man or one party control the state, we unfortunately not can be so today and then look how they today. Now this first point I get. No, thank you.
Thank you very much, Mr. Mustafa. Yeah, Mr. Mengot, anything you get to say before I say anything else? Let me read a comment here. Another lost case for the government. They allow the judge for sue the government. So we could see another rumble judiciary versus parliament. Okay, yeah, whatever that implies. But go ahead, Mr. Mengot, if you have something you want to say.
Well, I want to refer back to the Constitution.
Yeah.
Right? And it is very interesting. Section 140 of the Constitution now actually talk about the Judicial and Legal Services Commission. Section 141, subsection 1, it said there shall be established a Judicial and Legal Service Commission which shall have its administrative function and perform such other function as provided in the Constitution and any other law. But there's another interesting thing. When you go to subsection 2, it said the Chief Justice shall, acting in accordance with the advice of the Judicial and Legal Service Commission and save as otherwise provided, be responsible for the effective management of the administration. But the other thing is where it talk about, now when it talk about how then they deal with judges them, the Chief Justice get that right there, but disciplinary right. But the only thing is, the right is subject to the decision of the president. And that's not the issue. And remember, now as it pleases the Chief Justice, as it pleases the president, so then they appoint the Chief Justice. I don't know whether when he's appointed, he is subject to approval by Parliament. So you can see, if Indo make a recommendation to the Maui appointer, you feel say the Maui appointer go overturn that recommendation there? That is the issue.
Well, you see, the thing is, I don't know whether the people and what they set then regulations they are. They understand the purpose of regulations and the purpose of rules. Because if you understand the nature and the purpose of rules, everybody know, and I'm sure we judges them and we intellectuals they know, you cannot be the accuser or the accused and you participate in your own defense as an arbiter or somebody who get for make the decision. I mean, it goes without saying. So if the complaint is against justified or not, if it's not a frivolous, and they should even have processes whereby if a complaint is deemed frivolous, which means groundless, then forget a way for process that. But regardless whether it's frivolous or not, because the frivolous nature of the complaint could be based on the eyes of the beholder against who get the authority, not the one who makes the report. So what you do, there should be due process guidelines. Due process is a very, very important phrase. All the top of Constitution, due process is the key. Fair trial, transparency, opportunity for you to defend yourself, and the ability to have adequate notice. Because due process not going to allow, if a complaint is filed against you, then say, oh, you get 2 days for respond. No, that's not adequate time because you get to be able for make an assessment of the complaint against you. You get to be able for retain counsel. And so they just can't give you 2 days, 3 days, 1 week. Then for give you reasonable time for respond. Then again, for give you reasonable time for participate in your defense if there's going to be a hearing. The thing about this thing that the caller just not be to talk about, we are trying to distinguish here between a complaint and a hearing, because it appears as if there was a meeting, no, not a complaint and a hearing, a meeting and a hearing. So was it a meeting by the judicial body, or was it a hearing held by them? Because we don't see where one other lawyer who supposedly was present and was supposed to be part of that body, they say the rules call for him for a dissenting opinion, but he was not allowed. So again, all them phrases then they then so slack. He was not allowed. What did it mean? They affirmatively prevent him from making or altering a dissenting opinion. When I say affirmatively, say a grab, I say, I got something to say, and they say, no, sit down. Okay? Or he was not allowed because he was not called upon, because normally in a regular judicial courtroom procedure, when an allegation is made against you, the person who make the allegation and get the burden to prove his allegation by way of a testimony by him alone or by testimony of other witnesses, and we will involve several things. Then the body or the arbiter of the people who will sit in judgment of that grievance day go always or must always give say to both parties, but the party where the complaining will say, again, for let the body know, say, well, this is all I have to say. Then if I ask the person against whom the complaint is being lodged and said, do you have anything, any question? Due process call for you for be able to cross-examine the person will complain. See, due process goes both ways. So therefore, ask you, say, you have any question for the witness? And if you say no, then for them to also ask you, do you want to testify on your own behalf? you, the person against whom the complaint is lodged. Then if you say no, then they will ask you, say, do you have any witnesses? And then we'll ask the complainant that. You have anybody, you have any additional evidence? When I ask you that, there is a general thing for, say, additional evidence could be by testimony of someone, or additional evidence can be by documentary evidence. We document, then we can present in evidence for backup what you say. It can involve a series of things: newspaper clippings, video, recording, and then so due process is important. So now this lawyer say he was not allowed or he was not given. But when you say you were not allowed, there's an affirmative action on the part of the authorities then prevent you.
I just want to make one clarification, Mr. Shillon.
Go ahead. Yeah.
Okay. If you look at the man we say we they talk about Justice Reginald Flynn, right? Who is a justice of the appeals court and is a member of the Judicial Service Commission, because it says here, when you look at the member, it must be a most senior justice of the Court of Appeal. So he did it as a justice of the Court of Appeal. So he's a member of the GLSC. But the other interesting thing is, there is one person who should be represented, a practicing counsel of not less than 10 years standing, nominated by the Bar Association and appointed by the president. You see?
Well, I don't know why all this thing by president, but go ahead.
Yeah. Even though that person is representing the Bar Association, but now the Bar Association of itself don't split, because you get the Lawyer Society, where a breakaway for the Bar Association. We don't give their own statement. The Bar Association, as far as we know, then say, well, they hope, say, the tribunal go meet and due processes will be followed. So if you see the judge, we get that dissenting view, is a member of the GLSC, when an appeal court judge, but you also get a representative of the Bar Association. The Bar Association not come out with a strong statement on that, but we get a splinter group when at the Lawyer Society, when I break away from the Bar Association, we say the president for reverse that decision day. So you see the problem, even among the lawyers, that they bring this up because these are the people who would decide this judge in fate. So that is the issue at hand.
Well, that just shows you how they should be talking about streamlining, because these are just bad laws. And no matter how you turn them, because that should not be a call for the president at all. The president don't forget any role now. Then forget mechanism in place whereby when the body meets, and in fact, this initial meeting with this Justice Reginald Flynn with the talk about, I still ask the question, was it a meeting, was it a hearing? And now if it was a part of the commission or the body that met, well, I do not understand what he means by, well, they not allow him or they not be permit him for give a dissenting opinion. If that's the process, how do you stop a member of if the process calls for dissenting opinion? I just don't understand how can he be prevented as being part of the body from stating a position or opinion. So to me, it looks like it comes from just poor draftsmanship. They have not clearly spelled out in great detail the procedure whereby one can have his due process rights intact. So, but if you listen to the whole process, it's just a little confusing. Now we get a constitutional, and the constitution involved in this. That's what making it so much more complicated, a simple matter. And then, Mr. Mengot, if I understood you correctly, you say, then when you don't go through all them processes, then it could go for the ouster of that judge day to be confirmed or affirmed. It can go back to Parliament, or am I mistaken?
Yeah. Okay. Now there's a split. The Bar Association say they will never comment on the substance of the allegation for avoid prejudicing the work of the tribunal. However, they talk about fairness, transparency, and speed in handling the case. The association then agree with waiting to happen. But the Lawyer Society then say the procedure of suspension is unconstitutional. He said because they not adhere to them according to section 1375 and 6 of the Constitution. So, now look section 137 because now waiting and say. Section 1375 say if the Judicial and Legal Commission represents to the President that the question of removing a judge of the Superior Court of other than the Chief Justice under subsection 4 ought to be investigated, the President acting in consultation with the Judicial and Legal Commission shall appoint a tribunal. That's fine. The tribunal appointed under this one shall inquire into the matter and report on the facts of the case. So you see, now that they talk about where the removing of the judge of the Superior Court has been referred to the tribunal, the President may suspend the judge. Yeah. So this is the case, because whatever the case they happen, even everything is subject to the determination of the President.
Yeah.
Right? And after the determination of the President, even when they get the report, now, in the decision or for dismiss the findings of the report. So the final judge, now the President, not Parliament, not the GLSC.
Now, how ridiculous can that be? You know, you get a president who is not a member of a judicial body, but ain't gonna become the final arbiter of decision reached by a judicial body based on nothing, no guideline that we know of. But this is Sierra Leone for us. So when we get in legal bodies there, like it's
not final because if he approve the findings of the Judicial Service Commission, say this man, therefore, get rid of him, he's found wanting, he is the one who referred that report to Parliament.
Well, okay, let me stop you right there. Okay.
Yeah.
No, but I find that procedure kind of strange. You go through a judicial process.
Yeah.
Okay. You reach the highest level within that process there. Then you revert or you refer. Now you're going back to Parliament where the law that is being questioned directly or indirectly originated. So you go all the way to judicial service, you get the President, then you reverse back, you reverse to Parliament. I mean, it's so confusing. I can't even wrap my mind around it. How a law for work that way there. Because the President, first of all, should not be involved in any judicial process. Neither the President, the President, nor his office. Never be involved at all. I don't know of anywhere where the only time presidents can get involved in any kind of material, now like in a dictatorship. But in a purely constitutional, constituted country, the president should not have any judicial say-so, any say-so over any judicial process. So this is so confusing to me. And I don't know why. Well, maybe because people are just now getting adjusted to this constitutional issue, so maybe seem as appalling. But why is and then people still don't understand why the president cannot be involved. The president in ahead of the executive. He should not have a definitive role to play in the legislature, and he should never have anything to play, any role for play in the judiciary. So the way they for craft this situation, this problem where they happen between the judge and the chief justice, the judge for be given the right at some point in time for move out of the administrative process to go into the judicial process. We'll go raise constitutional issues, in terms of due process, in terms of freedom of speech, in terms of deprivation of property, in the sense that the judge is claiming he has been prevented from working, he is not being paid. So this is a right to property that he's being deprived of. But I don't see it any other way. This is the thing that confuses me. And so they're trying to make sense out of this. But one way to streamline the process is to get rid of the power, the connection with the president gets in terms of being able to fire or even able to make decision for the firing of someone in the judiciary, as well as parliament. So I think that those are two things that want to discontinue, which I don't think they have the courage to do, because opposition think they need that, then functions in there of the president in case they didn't have power. And the current government obviously think, well, not only we write the law, but now so a day, it work to our advantage, so we don't even care about the unfairness of it. That's the way it looks like to me. But me, that's the question, if we're serious about trying for, and every now and then judges themselves are becoming victim of it. Like what would this so happen between Justice Halloway and the Chief Justice? Will never happen anyway. Such a thing should not be so openly to the public.
I can give a way forward, right? Look at it if you want to streamline the system. Number one, the Judicial and Legal Service Commission, according to the Constitution, now they get right for transfer them, now they deal with the administrative and everything, right? So the Chief Justice now get that power there. So you can get the Judicial and Legal Service Commission headed by an independent judge, a retired judge. And then you sort of make sure, say, you remove the responsibility or the position of Chief Justice and Minister, the Minister of Justice or Attorney General. So if you have an independent JSC, when they take a decision, they should refer that to the Attorney General, who will now constitute a tribunal, and then that tribunal will make a decision which will be referred to Parliament. And then for change that law of a statutory instrument where you get a 2/3 majority for
if you are opposed.
And if you are opposed, they can make a simple majority. But also the statutory instrument, as I know, should be backed by an explanatory note referring to the Constitution, referring to breach of procedure, referring to misconduct according to the laws of the country. That is where the fairness not there.
Okay, so in other words, even as the law is right now, they are not following the dictate of the law as it is right now. They're not to follow that. So like them, the statutory notes, they don't seem to do that. Is that correct?
Well, every statutory instrument should be backed by an explanatory note.
Yeah.
What is the reason for that explanatory note? It gets for show how that decision or that law and the statutory instrument relate to either the Constitution or another law, or how it contradicts. Then that statutory instrument for say you just go pass them, if they not get objection, 2/3 majority, it becomes law after 21 days. That is a process which I think is very unfair, because the use of that statutory instrument they are not used for cause a lot of problems in passing laws them in the country. We're not fit for purpose. We're unfair. That is based on my own experience working within the parliamentary system.
Yeah, and the question I want to ask, there are laws that are being passed without explanatory notes. Is that correct? That they are not supposed to do, but then they...
I'll give you an example. Let me give you an example. If you remember, when we been get, I think it was Ebola or COVID, or one of the COVID, I think it was COVID. You remember the Minister of Justice, at the time, the Attorney General and Minister of Justice, present a statutory instrument to Parliament for a state of health emergency, which Parliament approved. But that statutory instrument did not have an explanatory note. Justified the state of health emergency. Now, after it expired, when they want to introduce them back, now that's when they say, well, now it should have been backed by an explanatory note. So something like that happened. Every statutory instrument should have an explanatory note. A second situation where that happened, it happened, if you remember, the statutory instrument will establish the PR system. The explanatory note came after, because at the explanatory note, now decide the threshold. But when the statutory instrument was taken to Parliament, the threshold was not part of that. So it has happened before.
Okay, so my question is... Okay, my question is, when it happens like that, since it is required, in essence, if Parliament claims that that law is passed...
Since it is required, yeah, it is up to that's where our legal profession,
that's the question I was going to ask. It can be challenged.
That's why I think they are not doing service to the nation, because lawyers should challenge that. It is their role to go to the court to challenge whether you can issue a statutory instrument without an explanatory note will refer, because a statutory instrument is a secondary legislation, and every secondary legislation must relate to first the primary legislation, which is the Constitution, enough for contravene the Constitution, and any other law, which an act of Parliament, even that very act of Parliament, must reflect it. So that is where we get a lot of laws where they get them wrong. I am not a lawyer, but I am well grafted in parliamentary principles and procedures.
All right. Well, I agree with you. So because some of their laws here are not being challenged, so they become, well, we're going to say, they become laws by, I would say by default, because people don't challenge them. So it just operates, and the court on their own, well, the court on their own then can raise the issue, if it ever comes before them, as to the illegality of a legislation with them pass. But I don't think we would have reached that far, whereby matters come before the court, even if the issue is not raised by a respondent or proponent of the law, because the court on its own can notice some illegality of it and raise the issue on its own. But I don't think we would have reached that level, if the issue is never raised, if the matter is before the court, and even if the issue upon which the law is being challenged, that the courts are still empowered to raise their own issues, collateral issues, that are not before the court, but are also relevant to the issue at hand. So the matter gets a little kind of tricky in terms of constitutional law practice. So, but this is the thing.
It is for that reason countries like South Africa and other countries them get a constitutional court. And there has been several times when people in the talk say, even Sierra Leone self, given all the issues that they get with the constitution, there is a need for a constitutional court. Take, for instance, what is happening now. We are now reviewing the constitution. And we review the constitution as part of this tripartite thing. And we hear the Attorney General, they say certain sections of the constitution which are not entrenched clauses can be, those sections of that constitution can be amended using a constitutional statutory instrument. And that will create the same problem.
Of course, yeah. I don't think the Attorney General is right. I think they'll get I think the safest and the easy process is by referendum. But I don't know.
That's it.
If Parliament.
So you know when they review constitution, you say part of the constitution, you go review and to statutory referendum. Then when you don't review the one, then two statutory instrument, then you get the one by referendum. Then you kind of say, Lord, combine everything together and take unto the people. And some of these ones which they wanted to, where they are going to be changed by statutory instrument, refer to things to do with electoral management systems. And I think we're in for a rough ride in the next couple of years leading to the 2028 election.
Well, that would be sad because I don't see a deep commitment to really trying to pass laws that will withstand the test of time. I don't see an effort on the part of our officials. Even when they talk about the tripartite, when they talk, say, they have, like Minister Sengedi say, they don't comply with significant part of it. That is, and then nobody seems to know anything about that. So they're doing all this reviewing in secrecy. They are not getting the input of people who can make a meaningful suggestions to the end of the day. It's a little troubling. I don't think you run a country that way. It will be problem after problem after problem while other countries are moving forward and just stabilize their constitution. We are playing games with it. So it will always be an issue. And now, even if they look some of the comments, going back to Justice Momoja Stevens, I mean, it's interesting how people view things. Some people, the 2-3 comments I see, then say, oh, the woman. So I think somebody say, so you're after the money of Momoja Stevens. You know, I find that comment very interesting. Why shouldn't she? If not in Peking, is it not his obligation for provide adequate support for in Peking? So what's wrong with her being after her money? But you see, people take simplistic view. Say after her money. And I listen to the young lady say, money, money, money. You can chop a money to the fullest. Well, I guess the answer is yes. Americans have they have a saying, never get your money, never get your honey where you're getting your money. You know? So, I mean, what I see nothing absolutely wrong in her wanting to take care of a child that she claims is fathered by the judge. If it is true and the judge has adequate opportunities or a means by which, if he questions fatherhood, I mean, the law get a modern way whereby the judge can ask for a DNA. So we also understand, say, the judge took an assault warrant on the woman for assaulting him, and she's been accused of domestic violence. Well, my colleague, Mr. Mengot, pointed out something the other day, say, well, if she's being charged with some domestic violence, which means they're sharing their lives together, they live, and they live together, you know, so there is some sort of a relationship which kind of confirms the young woman in accusation. And normally everywhere in the world, you support a child based upon your earning, your ability of what you to bring in. Now, but here is a misleading, I think, or an assumption or a presumption that I think sometimes we have to be careful about. Because the young lady, the talk say, well, the judge get money. I mean, she may have a basis for that. I get money because I'm a judge, or I get money because she knows, as a matter of fact, you get wealth by inheritance or by ownership of certain pieces of property. But she's making this categorical statement, or she's just assuming that because he's a judge, he makes a lot of money. Therefore, he get plenty money, because the judge having money and not taking care of him picking are two different things. Because whether you not get money safe, you have to take care of your picking. You see, so we have to move away from the old system, okay, whereby a man just thinks, say, he can go get a woman pregnant and then walk away without any responsibility and leave it all to the woman to raise that child for the next 18 or more years. I mean, the world has moved too far for even get that kind of mentality there. We also you not necessarily get for marry the woman with whom you have a child. But if a child comes out of that relationship there, and there is no question on your mind that that's your child, the law must or should make you support that child. You see? So when we look at this situation, not only is it scandalous, and the Judicial Service Commission, they all get involved, then you hear the young woman say the judge was engaged in what you may also call obstruction of justice, in the sense that it makes security people prevent, and this is an accusation, we don't know if that's true, that she was not able to go to court because the judge and security people you can't do that, because you are interfering with the administration of justice. You know, so judges can be in violation of the law just like ordinary persons. Somebody want to go testify in a court, and you know, send a vital witness, you go set your house on fire, or go deflate your motor car, wait, I'm going to court, or something for making not going to court, that's a crime. Now you go make people in hold or detain them. That is a crime.
Okay,
that's justice.
My comment on this, it comes back to what I always talk about, institutional lapses.
Indeed.
You get three institutions involved. Institution number one is the law school. Remember, this lady is a law student. The man where they allege, say, abusing rights or do whatever, is a lecturer. So there should be code of ethics in the university for prevent issues between lecturers and students. Because you remember, we don't get a lot of cases when they talk about sex for grades and all those sort of things. So the university gets a right, for look at this issue ethically. Then next, the police. She must have reported it to the police. And if she had reported it to police, social welfare people in Kansai.
Indeed.
Because you get people where they deal with child support. For me, the way that lady they come out in the video, she seems traumatized. it look like person will need help. Even listening language, the way of communication, right? Then they say for kind side, right? Of course, we don't get the much trumpeted hands of our girls. Then the third one, the same GLSC, the Judicial and Legal Services Commission, if then they see this thing, for me, they should look into the matter, because an issue like this, a senior judge is being accused openly like that. It's a misconduct, because the judge should be held with the highest integrity. So what is different? Yeah, it's a misconduct. Not say the accusation where the lady they make right to. No. I cannot ascertain, say, as we know, we all know the saying when they say hell hath no fury, like a woman scorned. Yeah? So I know they justify, say, the lady for do things like dandy. But then this is the thing, the judiciary will get code of ethics for judges. We never even take any issue. We never hear the university take any issue. So the institution don't fail a lady who is traumatized. She's probably suffering from PTSD. So that's my concern. Now the lack of our institutions for protect the vulnerable. Nine are the issue here. As I say, we'll get only 5 minutes more to the end of the program. I don't know.
Okay, yeah, you're right. So we can end the program with this topic, or you have one we can deal with, a short one we can deal with?
Well, we've been talking about this new bill where they go through Parliament under the Data Protection Bill. But as I said earlier on, we don't look for this bill. This is another thing where we need for express now this program. If there's a bill going through Parliament where they deal with key issue about data protection, how government they handle with data, and as I've been mentioned in the introductory thing, data for deal with, we don't really say the telecommunications company then forget with data on the national identification number things, with data for get telephone, for get access to telephone, driving license and all that thing and they. So we the appeal, and I'll try see if I can send a message to the Ministry of Information, because then they promote this bill. If they can make that bill available to us as citizens, I can few reviewers and say we will look into the bill in our next program, provided it's available. Then it comes back to Parliament. If you go to the parliamentary website, you look for ongoing bills and where they go through for this 2025, there's not a single one. Also, we get the right to access information commission, where then self now people away from make sure say information go out to the people. Even the Ministry of Communication and Civic Education, yeah, right. Therefore, they make we know. But before I go further, there is somebody who say a wrong example was set on Lara Telopias. The committee never called Lara to testify, but filed witnesses to testify. The decision was forwarded to the president. Parliament voted, and she's out. Well, again,
you see, okay.
Again, it comes back to what we talk about, the processes and procedures.
Exactly.
Right? Because removing the Auditor General is the same way the procedure, if they want to remove this judge, now the same process to go through. So now let's wait for the tribunal. Let us see what thing will happen. That's my only comment. So over to you.
On the Laura Taylor Pierce example they're giving, people don't still understand the gravity of the right to due process. Due process does not leave it up to the judicial body or the authority to call someone to testify for herself or anyone else. Due process demands constitutionally. These are the arguments. So you see, it upsets me when I hear people talk about due process and this thing is not taken to court to challenge that process. The process itself is flawed. It's flawed. Because when they say the committee never called her, it doesn't have to be the committee's discretion whether to call her or not. Due process demands that she testifies. So I don't know what kind of rules they had, hearing rules they had at the hearing in terms of testimony or testifying, but it should not matter. The committee should not have the discretionary power to allow, permit, reject someone to testify. Due process demands that. So if Taylor Pierce now testify, I wouldn't put the blame solely on this, because there's a reason why we're all lawyers. We try to get into them here. You challenge the fairness, the legitimacy of the law. So if the committee, you raise the issue so it can be on record that you want your client to testify, they don't have to. It's not, I mean, I don't think, of course it's their duty, but it should not be their right to say your client, or they have the authority to prevent your client from testifying. So Taylor Pierce should have testified, and she should have called witnesses on her behalf. But I don't know how to set that procedure there. And anything else, knowing the current situation back home, your lawyer should be ready with brief memorandum for go to court and challenging the law. Now, even if we do not get faith in the system, let the record reflect, because history one day will judge you, the lawyer, will do that case there, then go judge the prosecutors, then go judge the body will sit down on the case. But you cannot just throw in the towel and say, well, no point for going to court. You have to, because we have a constitution. If we don't take these matters to court to challenge legitimacy or illegality of their laws here, they will become, I don't even want to say they will become law because they are illegal, but they will become the standard by which people are being punished or affected. The parliamentary website in Sierra Leone is not fit for purpose, can't be compared to a primary school website in the West. That may be true. But so the Taylor Pierce situation that she was not allowed, just like other judge to say, allow for get the dissent, enough for be the right of the body forgive. It shouldn't be an option. It has that right. They should be waived only by the affected person who is being accused. Let me read one more. A wrong example was set on Lara. Oh yeah, the same thing. She was never called to testify. Well, she didn't have to be called. She should have offered to testify on her own behalf and be allowed to call witnesses. And if they deprive her, that should have been the basis of our appeal all the way, because that power doesn't exist. The Constitution gives her the right to testify on her own behalf. The Constitution gives her the right to due process. And testifying on your own behalf and calling witnesses is part of the accorded due process that the system must follow. So you see, there is still procedural problems that we're having. We're not putting proper procedures in place, and we're not making effort towards them. We need some basic things, then restructuring of a foundation. If we lost them and many other things before we begin to move forward. So when I see the other day, then they talk about they want to implement plea bargaining. I'm saying, what is the matter with these people? How many of them know anything about plea bargaining as operated? Because plea bargaining, if you don't watch out, it will promote corruption. much bigger than the problem we'll get now. It's a good thing they practice here in the United States, but you need people with practical experience having dealt with a system that has the bargaining. Not the thing where you just read in a book and say you implement them, because it takes other factors to get it going. And these things sound attractive, fascinating, when you read them. And when you come up with an idea, but I think it's time for some of us who know something more for the raising issues here. Let these guys don't think, well, they can just run roughshod over people. You are not helping the country, and it's a shame. When I get to do better than that, when I try to ensure to the highest standard, fairness, transparency of the judicial system, but judges engaging in misconduct, unethical conduct, nothing is coming out of it. This young woman, they claimed that she was raped. Rape is a crime, and the police wouldn't do anything about it. The police should not have an option. What system is this? Now, police will decide whether somebody, when a woman comes and complain about rape, the police for take a statement, and I don't think that point they say if you make improbable cause, you will not get for press charges. That's why the person get a lawyer. When it goes to court, then we'll do probable cause. Then we'll try to determine if not frivolous complaint the woman make, or there is some reason for proceed with the case. So we are killing the system. We are undermining our own system, one for one government, and people on the outside. The people who come there and invest a lot of money, they just see an opportunity for exploit the country. But they themselves think, no, they are not safe in terms of, because nobody wants to pour millions of dollars in a country where the laws are weak, where the laws are being undermined by the system itself. So, having said that, that's all I got to say for the program, because we're a little bit beyond time. So I think for the things that we will not get to this time, one of which now this ID system, within the chalkboard. In fact, I was going to touch on the national ID that they talk about to be linked with the telephone numbers, but we'll deal with that next time again. We will not talk about that before, but we'll deal with that next time. Until then, again, let me see a comment. Lara's lawyers filed a case in court, but there is no hearing. Well, okay. So until then, until we meet again and talk again, as I want to say good night to you, and thank you very much for our participation, sending in on our comments, listening to me and Mr. Mengot. They throw we only to bit where we know say go help the system. So let me pass on over to Mr. Mengot. So good night, everyone. Until next week.
Well, good night, everybody. Until we meet again, stay safe, and hope we'll get more things for discuss with you now.